Welcome all to this webinar organized by Lydian. My name is Bastian Breunus. I'm a partner at Lydian and I'm heading the technology and data practices within Lydian. It's an honor to have you here with us today for this specific webinar. Maybe let me first explain a couple of housekeeping rules. First of all, the presentation that you will see can be downloaded on the right-hand side of your screen under handouts. Secondly, during the webinar, there will be two poll questions to check your attendance and your attention. But those poll questions, your answer to those poll questions will allow us to provide you with a certificate from GoToWebinar at the end of the webinar. And then third, housekeeping matter, questions can be asked through the chat box. Do not hesitate to pose any questions to us via the chat box. I am not sure that we will be able to handle those questions at the end of the session, given that we have quite some information to provide you with. But in any event, if you have any questions, we will come back to you by email and respond to your questions separately. So having said this, let's start with the webinar. What are we talking about today? I thought it was a good idea just before the summer to give you a bit an update of everything that is cooking or boiling at the level of the European Union in the area of digital and technology. Indeed, the European Commission has declared digital and specifically a Europe fit for the digital age as one of its 6 priorities for the next 4 years. And indeed, it contains 3 pillars, among which fair and competitive digital economy. If you look at the Digital Europe program, it acknowledges that digital technology and digital infrastructure have a critical role to play in the lives of everyone and also in the business environment. And so there are different projects that have been developed by the European Commission, and 6 of them are quite important. It's projects about supercomputing, about artificial intelligence, about cybersecurity, about advanced digital skills, and last but not least, ensuring a wide use of digital technologies across Europe. In the framework of these different projects and around these different themes, the European Commission has made a whole series of proposals, legislative proposals, that are coming towards us and coming towards you as a legal counsel. And the purpose of this webinar is in fact to give you a short overview of these different legislative initiatives. The purpose is not to go into the detail of each of these legislative initiatives, but really to touch upon 4 things. First of all, what are the objectives of this new regulation or this legislative initiative? Secondly, what are the key points of attention for you? What's in there? What are the main features? Third, what is the likely impact for you as a company or as an undertaking? What should you take into account? And then last but not least, what are the next steps in this area or for this legislative proposal? Where exactly are we in the whole legislative process? So this is the structure that we have taken, and let's immediately start with the first legislative initiative. And in fact, this is already a directive that has already been voted and that is already in place. And it is the Omnibus Directive. Now, the Omnibus Directive, first of all, what is the objective of the Omnibus Directive? It's a Directive 1921/61 of 27 November 2019, but I will come back to that later, that basically regards consumer protection. And it builds further on two directives of 2019, Directive 2019-770 and 2019-771. Those two directives of 2019 have updated themselves a directive of 1999, which in fact only applied to goods, but they have updated it to include digital content and digital services. And these directives now contain detailed requirements for either goods with digital elements or digital content or digital services, such as features like functionality, compatibility, interoperability, and also security updates. What is the purpose of the Omnibus Directive now? Well, as said, it builds further on the directives 2019-70 and 70-71, and it amends a whole series of consumer protection related directives in order to harmonize and modernize the whole framework of consumer protection within Europe, keeping in mind everything that is digital, so digital content, digital services, and goods that contain digital elements. What are the key points of attention now for you? What's in there in the directive? Well, first of all, a number of additional pre-contractual information requirements. And I give some examples. I will not explain them all, but for example, there are transparency obligations regarding personalized pricing. If personalized pricing is done on the basis of automated decision making, and you see the link with the GDPR, there are additional transparency obligations or pre-contractual information obligations. Also, online marketplaces have been imposed a number of additional pre-contractual information requirements, such as indicating whether a third party that is offering goods or services on the platform is a trader or not, and also making clear whether this trader will apply consumer protection rules, yes or no. There are also some rules regarding ranking, which are similar to the platform to business regulation. And in general, these say that ranking should be based on transparent information, which is general, succinct, easily and directly accessible information on the main parameters of this ranking. And also obliging platforms to indicate whether advertisements or whether certain items that are ranked are paid advertisements or not. And last but not least, a number of rules regarding customer reviews. This directive also contains a rule, very importantly, that consumer rights apply whenever a trader supplies digital content or digital services in exchange for personal data. There are some exceptions to this, but the rule is that whenever certain digital services or content is being offered for free, but in exchange for personal data, the rules on consumer protection will apply. And then last but not least, there are some changes that are being made to the right of withdrawal, including a number of additional obligations being imposed on businesses, compliance with GDPR, and also, for example, refraining from using content provided or created by the consumer, save certain exceptions. What is the impact for you? Well, first of all, the modernization of everything that relates to consumer protection rules is of course relevant to a whole series of traders and undertakings. So meaning prepare in time, re-evaluate your activities and follow up on the implementing legislation. Also note that Non-compliance with this directive will lead to GDPR-like fines, for example, to counter widespread infringements, and fines, and we are speaking about fines of about 4% of the annual turnover in the member states concerned, or 2 million euro if the annual turnover is unavailable. As said in the beginning here, this is a directive that has already been voted. It is in place, but it must still be transposed in the different member states. The deadline for transposition is the 28th of November 2021. However, here in Belgium, there is still no Belgian bill or act that is transposing this directive. The aim is that the measures taken to comply with this directive should be in place by the 28th of May 2022. So still some time, but remember, Belgian legislation must also still be adapted. A second proposal, and here we are talking about a legislative initiative, is the so-called Digital Services Act. Now, the Digital Services Act, what is it about? Well, basically, you will be familiar with the 2000 e-commerce directive. This e-commerce directive of 2000 is in fact today outdated. The digital environment has changed. It poses new challenges. For example, the rise of those great platforms that have taken a major role in the digital economy has not been taken into account in the 2000 directive. And also, for example, the illegal trade that is being carried out on digital platforms today, or in the digital environment in general today, has also increased. And so there was a need to amend and replace the e-commerce directive of 2000. The aim of the Digital Services Act is indeed to provide for uniform and harmonized rules to foster innovation, growth, and competitiveness, and also to ensure increased transparency for consumers. Now, what are the key points of attention? What is in there in this proposal? First of all, the scope of application. Scope of application will be all providers of intermediary services, so ISPs, Internet Service Providers in the internal market. Whether or not they are established in the EU or not will not matter, as soon as they provide services to recipients in the EU, those intermediaries will be caught by the Digital Services Act. Also important is that this Digital Services Act, the DSA, will be applicable to smaller players also, but the exact obligations will depend on their role, their size, and the impact that they have on the online ecosystem. And of course, there will be more obligations for larger players, what we call then online platforms, and even more obligations, more regulation for the so-called very large online platforms. The DSA also handles the issue of liability. This issue was also in the e-commerce directive. As you know, there was a kind of safe haven created for online intermediaries, and the DSA maintains this principle of safe haven, but with a number of changes, with a number of new liability rules. What are those? Well, for all ISPs, there will be obligations for increased transparency. They should provide information to authorities based on orders that they receive to act against illegal content. They should also be designating contact points and legal representatives. They should be indicating what restrictions there are, for example, whether there is content moderation, algorithmic decision-making, and so on. And they should be publishing annual transparency reports. There are a number of specific rules then for hosting providers. They receive a number of additional obligations that relate specifically to notices and decisions on illegal content, including an obligation to introduce specific processes for managing notices on illegal content, and also the obligation to provide reasons for decisions and informing the recipients when removing illegal content. Then there are a number of additional obligations that are being imposed on online platforms and on what the regulation or the draft regulation calls very large online platforms. Online platforms will have a number of obligations in the area of managing illegal content, notices and complaints. So they should maintain an internal complaint system. They should use out-of-court dispute resolution or dispute settlement for complaints. And they should also give priority to so-called trusted flaggers that flag illegal content, and they should take measures against users that submit abusive notices. Aside from the obligations relating to illegal content, there will also be a number of new obligations regarding a transparent and safe online environment. They should ensure that advertisements are clearly identified as such. They should make sure that business users are traced in online marketplaces to help identify sellers of illegal items. They should publish more detailed transparency reports than generally required, and they should also report suspicions of criminal offenses to the authorities. As I said, a distinction is made between online platforms on the one hand and very large online platforms on the other hand. For very large online platforms, a number of additional obligations are being imposed, specifically in relation to managing systemic risk. What is the possible impact for your organization? Well, first of all, know that digital services coordinators will be established in each member state under the DSA. They will be competent to investigate complaints about breaches of the DSA, and they may impose interim measures and fines. There will also be enhanced enforcement by the Commission, specifically for the very large platforms that we all know. And again, fines are being imposed, and again we speak about fines that are GDPR-like or competition-like fines, such as 6%, 1% of turnover, 5% of average daily turnover, in case of daily periodic penalty payments. Where are we with the DSA? Well, the legislative process is ongoing. The proposal dates of 2020. It must still be discussed between the Commission, the European Parliament, and the Council of Ministers, European Council. This will probably take about 18 months, so it is expected that this regulation will probably be finalized either by the end of 2021 or in 2022. Once adopted, it will directly apply because this is a regulation. It does not need to be transposed into member state law, and ISPs will receive 3 months to prepare for the entry into force. Together with the Digital Services Act, there has also been a proposal for what we call a Digital Markets Act. Now, what is the Digital Markets Act? The Digital Markets Act relates more to everything that is fair competition in the digital sphere. This is a proposal of 15 December 2020. regarding contestable and fair markets in the digital sector. What does it aim to do, the Digital Market Act? Well, it defines the role and it regulates the role of the so-called gatekeepers, which are large online platforms that are basically capturing the biggest share of the overall value generated in Europe's digital economy. These platforms, they act as a kind of gateways or gatekeepers between, on the one hand, business users, on the other hand, the consumers or end users. They have a long-term entrenched position and they have market power. So contrary to the Digital Services Act, which is really about replacing the e-commerce directive, it's about e-commerce and so on, the Digital Markets Act is much more in the area of competition law. It's about fair competition. It's about gatekeepers. It's about curbing to a certain extent the power of the large platforms. What are the key points of attention in this proposal? Well, first of all, what are providers of core platform services? These are online intermediation services, such as search engines, such as social networking services, video sharing platform services, number-independent interpersonal communication services, even operating systems, cloud computing services, and so on. However, these platforms must meet certain qualitative and quantitative criteria to fall within the scope of the Digital Markets Act. And what does that mean? First of all, they should have a significant impact on the internal market, and this is being regulated via turnover thresholds. Secondly, they should operate a core platform service which serves as an important gateway for business users to reach their customers. And again, there are some thresholds that mean that there is a certain presumption that this condition is fulfilled. And then third condition is that they enjoy a long-term entrenched position in its operations, or it is foreseeable, it is even foreseeable in the future that they will enjoy such a position. So as from the moment that those conditions are fulfilled, those companies will fall within the Digital Markets Act and will be considered as gatekeepers. What will be the main obligations? And I will not go into the detail, but first of all, there will be an obligation to notify the Commission if thresholds are met. Secondly, an obligation to ensure freedom for end users, and you see immediately the different issues that we are tackling today against large platforms. For business users, this means freedom of pricing, for example, freedom to promote, and also freedom to contract outside of the platform. For end users, it means, for example, the freedom to uninstall pre-installed software and to install third-party software on their devices. A number of other obligations are also provided for example, data portability, a concept that you know from the GDPR. The obligation to make their services accessible to business users and others, and the obligation to provide transparent information about advertising and also about profiling. And again, this is coupled with a number of prohibitions on gatekeepers, for example, that they may not discriminate in rankings, that they may not require the use of their own identification service, that they cannot combine personal data without valid GDPR consent, and so on. What is the possible impact for your organization? Well, know that the Commission will be competent to investigate and impose sanctions. They will also designate those providers that are being considered as gatekeepers, or they can also exempt some gatekeepers from certain obligations if they feel that is appropriate. They may, as a commission, initiate market investigations and also adopt non-compliance decisions. Again, and I will not go into the detail, but again, substantial fines are being foreseen in the Digital Markets Act. We speak about 10%, 5%. So competition-like or GDPR-like fines are being imposed. Where are we in the legislative process? Well, it is ongoing. The Commission proposal has been launched, has been published in 2020. It still needs to be debated, amended, and so on. It needs to be discussed among the different bodies of the European Union. This will take about 18 months, and we expect it to be finalized by either the end of 2021 or in the course of 2022. Again, this is a regulation, so it will be directly applicable across the EU without any need for transposition in member state law. And here, core platform services that are being considered as gatekeepers will receive a term of 6 months to prepare and amend their own practices to be compliant with the Digital Markets Act. We have here a small poll question. Have you ever been confronted with gatekeepers who abused their market power? And up to you to respond yes or no. Okay, thank you for responding. Let's go to the next theme, the e-privacy regulation. This is another proposal that is on the table at the European Commission and among the European institutions. What is it about? Well, it is a proposal. The latest proposal dates of the 5th of January 2021, and the aim is basically to replace the e-privacy directive that we all know and that regulates today, for example, the issue of cookies or the issue of confidentiality of personal data or telecommunication data. What is the objective of the e-privacy regulation? It is to particularize and to complement the GDPR, ensuring at the same time confidentiality of electronic communications, both for existing means of communication and for new means of communication. And this is very important because Directive 2002/58 has indeed not kept pace with technological and market evolutions. It needs to be amended, and one of the aims, one of the objectives of the e-privacy regulation is exactly to ensure that not only the traditional telecommunication providers would fall under this regulation, but also these new systems such as voice over IP, messaging services, web-based email services, so meaning services that are functionally equivalent to the traditional telecommunication services and networks that we know. What are the key points of attention? Well, it protects end users in the European Union, and note that this concerns both natural persons and legal persons. So it is different from the GDPR, which only protects natural persons. Here it also protects legal persons that are end users of telecommunication or communication, electronic communication services. It reiterates the principle that electronic communication data, both the content as well as the metadata, is confidential, meaning that interference with such data, such as, for example, tapping information, listening in, storing, monitoring, using interception, surveillance, and so on, Any interference is in principle prohibited unless when expressly permitted by the e-privacy regulation. And examples of such permission are when it is necessary to maintain or restore security of electronic communication services, or, for example, when it's necessary to detect or prevent security risks, such as malware or viruses. And also, of course, when there are legal obligations, for example, in the area of detection and prosecution of criminal offenses, there again, there will be an exception to this principle that telecommunication data, both content and metadata, are confidential. The e-privacy regulation also deals, as the e-privacy directive in the past or today, still today, it also deals with the issue of using the processing power or the storage capabilities of the terminal equipment of an end user. And there again, it reiterates the principle that using such processing power or storage capacities is prohibited except when expressly permitted by the e-privacy regulation, and the exceptions are very narrow for the time being. It's either with the end user's consent or when it is strictly necessary for providing services that are specifically requested by the end user. Importantly is that on the issue of consent, the e-privacy regulation notes that consent can also be given by appropriate technical settings. So, for example, end users they would have the possibility to whitelist certain service providers in their browser settings or other settings, and this is specifically done in order to address the information fatigue or the cookie notice fatigue that we are all undergoing today. Last but not least, unsolicited marketing and marketing is also regulated by the e-privacy regulation. It is in principle prohibited unless either with the prior consent of the recipient, or secondly, when it consists or when it concerns a existing customer or an existing client, and there I refer to the regulation that we all know today in Belgium about existing direct marketing towards existing customers. What is the possible impact for your organization? Well, again, there are GDPR-like fines that are being imposed, 2% and 4%. Those figures will sound familiar to you. Make sure that you keep up to date about the developments in the adoption process of the e-privacy regulation, because it will have an impact on almost anyone that has a website that is using cookies. At least all of those will be subject to the e-privacy regulation. Everyone that is doing direct marketing via digital means will also be impacted by the e-privacy regulation. So quite important, quite far-reaching for everyone. What are the next steps? Well, and here I must say, first of all, if you have followed the story a bit, you know that the intent of the European Commission was that the e-privacy regulation would enter into force together with the GDPR, so 25th of May 2018. However, it has been impossible so far to agree between the different EU institutions to agree on a final text. And so the process is ongoing. The latest text is of January 2021. It's the Portuguese presidency that is now, in fact, trying to reach a consensus with the European Parliament based on this text of January 2021. Note also that even though this text of January 2021 is an important milestone. It is being criticized by a number of data protection experts, and also note that even when the text has been adopted, it will not be applicable until 24 months after its entry into force. So meaning, even when it is still being voted this year, 2021, it will only be applicable in 2022. Another proposal that has been made by the European Commission and that is on the table today is the artificial intelligence regulation. Now, what is the subject matter of this artificial intelligence regulation? It's a proposal, first of all, of the 21st of April 2021, so quite recent, and it aims to do two things. First of all, to provide for a legal framework for the use and the putting on the market of artificial intelligence systems, providing a harmonized legal framework. That's the first thing. The second thing that it also wants to do at the same time, and which is quite interesting, I think, is that it also wants to support innovation to ensure that the EU maintains or receives a leading role in artificial intelligence. And so it combines two purposes. On the one hand, trying to regulate it in order to protect users, in order to protect citizens, and on the other hand, also making sure that regulation does not kill innovation and providing for a number of systems that allow, for example, startups, scale-ups, and so on to still be innovative in the area of artificial intelligence. What are the key points of attention in this proposed AI regulation? Well, first of all, there are a number of AI systems that would be prohibited in principle. For example, systems that would manipulate human behavior, opinions, or decisions, those would be subject to an outright prohibition. Also, systems that are used for indiscriminate surveillance applied in a general manner without any differentiation, so large systems of, for example, facial recognition that are being deployed in public spaces would be prohibited in principle. And third prohibition is AI systems that would evaluate the trustworthiness of natural persons based on their social behaviors. So, for example, looking at their LinkedIn profiles, at their Facebook profiles, at their posts on Instagram, and so on, to predict, in fact, their trustworthiness. Also, such systems would be prohibited. That's the first category of AI systems that the AI regulation speaks about. Then there is a second category. The second category are those systems that are considered as high-risk systems. And I have given here on the slide a number of examples of what the Commission deems are high-risk AI systems. For example, systems that are being used during recruitment, promotion, or the termination process of employees. Or systems that are being used to evaluate the creditworthiness of a person. Systems used by public authorities to evaluate eligibility for public assistance, benefits, and services. Those AI systems, which are then called high-risk AI systems, those are being subject to a number of very strict conditions and requirements. What are those? Well, for example, there are, for instance, there are requirements that are being put on providers of AI systems, so those that put AI systems on the market. Secondly, there are a number of, but those are limited, a number of obligations that are being put on users of AI systems. So, for example, undertakings that buy or license in certain AI systems and that use them in their business operations. The whole AI regulation is very principle-based, meaning that those persons that are familiar with the GDPR will see back a number of familiar concepts in the AI regulation. Concepts such as risk, such as management of risk, concepts such as transparency, and so on. Aside from the obligations that are being put on AI providers and AI users, as I said, there are also a number of measures that are being put in place to support innovation. What are those measures? For example, there will be AI regulatory sandboxing schemes. This is something that is, for example, missing in the GDPR. The GDPR regulates everything that is being done with personal data, but it does not contain any sandboxing mechanism to allow innovative firms, startups, and so on to play a bit without being subject to the entire GDPR. Here, the Commission has thought about this. They expressly want to regulate it on the one hand, but on the other hand, to also ensure that the competition is not hampered. And they have put in place a sandboxing scheme, or they propose to put in place a sandboxing scheme. And also they propose to put in place some measures to reduce the regulatory burden for example, small and medium firms and for startups. Again, substantial fines are included in the draft AI regulation: 10 million, 20 million, 30 million, 2%, 4%, 6%. There will be national supervisory authorities such as the data protection authorities that we know today, but competent for everything that is AI. And similar to the system under GDPR, there will not only be national competent authorities for AI, but also an AI board, the European Artificial Intelligence Board, that is then composed of representatives of the different national AI regulatory authorities. What are the next steps? Well, this is a proposal that is very recent. It dates from April 2021. It is very likely that adaptations will follow. I think the whole of Europe and all stakeholders are looking at the text today, are formulating proposals for amendment and so on. So if you are a stakeholder, if you are using AI or you are developing AI, please make use of this opportunity, in fact, to try to influence the final outcome and the final text of this AI regulation. Once it will be adopted, it is foreseen that there will be a period of 24 months for implementation, save a number of exceptions. So it is clear that this will not be in place, this will not enter into force before 2024. Then another proposal that is on the table of the European Commission is the Data Governance Act. Now, what is the Data Governance Act? Data Governance Act is a proposal of the 25th of November 2020. It's a proposal for a regulation on European data governance. And it's basically the first set of measures, or the proposal is framed in a set of measures that has been announced already in 2020, the so-called 2020 European Strategy for Data. What are the different goals of the Data Governance Act? Well, first of all, it is to facilitate data sharing and reuse across the EU and between different sectors. So think about, for example, the energy sector, mobility, health, and so on. The aim is to ensure that data are much more accessible under conditions that are, and I'll come back to that a bit later, on conditions that are fair, transparent, and that the data are accessible to anyone. Second objective is to increase the control and the trust of both the citizens on the one hand and companies on the other hand, and including data intermediaries in their data itself. As we know, trust of everyone in how data are being handled is key in ensuring that data are also made available to those businesses and undertakings that want to use those data. Third objective is to offer, in fact, an alternative European model to the model that is currently being used by large technology platforms, and to create a basis for a new European way of data governance that is in line with the European standards, for example, the standards on data protection, the GDPR, but also standards on consumer protection and competition law, not to forget. What are the key points of attention? So what is basically in this proposed regulation? Well, first of all, a number of mechanisms that aim for an enhanced use and reuse of public sector data. So public sector bodies that decide to make available data for reuse, there will be no obligation to do so, but if they do so, they will have to comply with a number of requirements. First of all, the existing obligations under the GDPR to the extent it concerns personal data, but also a number of existing protections such as commercial confidentiality, intellectual property, and so on. Importantly, public sector data or the public sector that wants to share data cannot do this on an exclusive basis. So there is a prohibition on entering into exclusive arrangements subject to a number of exceptions. And when they want to make available public data, they should do that in a transparent manner and be transparent on, for example, the conditions for reuse. And those conditions must be non-discriminatory, proportionate, and objectively justified. So that's for public sector data. Second big part of the Data Governance Act relates to a number of measures to facilitate what we call data altruism. So what do we mean thereby? It's about individuals that come and companies that voluntarily make data available for reuse without compensation, and this for the common good. And the Data Governance Act wants to regulate this and wants to push this also forward. So what does it provide regarding data altruism? It provides for a possibility for organizations that facilitate data altruism to register as a so-called data altruism organization recognized in the Union. And there are a number of conditions, of course, that are imposed to be able for an organization to register as such. What are those conditions? For example, it should be a non-for-profit organization, first condition. Second, it should be a separate legal entity, a separate legally independent structure, separate from other activities, and it will be subject to a number of transparency obligations. Third big point in the Data Governance Act is data intermediaries or providers of data sharing services. There again, the aim, the objective of the proposed Data Governance Act is to create trust in those data intermediaries. And here it introduces, in fact, a model that is based on neutrality and transparency. First of all, transparency, there will be a notification and compliance framework. So They should notify the relevant EU member state authority of their intent to provide such services. Secondly, they should appoint a European representative if they are outside of the EU. They should put their data sharing services in a separate legal entity, and they should have in place appropriate security safeguards. These are the obligations on transparency. Aside from that, there are a number of obligations regarding neutrality. The data sharing intermediary cannot deal with the data on its own account. He must remain an intermediary. He cannot sell it, for example, to another company or use it to develop its own product based on this data. And they should at any time act in the data subject's best interest when facilitating exercise of data subject rights under the GDPR. What is the impact? Well, first of all, again, non-compliance may result in fines. There will be monitoring and enforcement of this Data Governance Act by national supervisory authorities. And again, similar to the GDPR, a specific organism, a specific body will be created at a European level, the so-called European Data Innovation Board, again composed of representatives of the different national supervisory authorities that are tasked with monitoring compliance with the Data Governance Act. Here also, this is a proposal. We are in the stage of the legislative work. The legislative process is ongoing. The Commission's proposal will probably be debated, will be updated, will be amended. Once adopted, there is no timing foreseen for the time being, but once adopted, it will enter into force after 1 year and will be directly applicable. It is, after all, a regulation that does not need to be transposed into member state law. A poll question: are you currently using and/or developing artificial intelligence? Okay, thank you everyone for answering. We have 2 more proposals to go, 2 more proposals that are on the table of the European Commission. The first one is the Digital Operational Resilience Act, the so-called DORA, Digital Operational Resilience Act. What is this? It is a proposal of the 24th of September 2020 for a regulation of the European Parliament and of the Council on digital operation resilience for the financial sector. And this is important, so where should you situate this proposal? It's a proposal that is relevant for the financial sector. It is in fact also part of the so-called digital finance package, and the goal is in fact to adopt harmonized legislation regarding digital operational resilience, including identification, mitigation, management of cyber risk, also management of third-party risk, such as outsourcing, and also management of the so-called concentration risk, when too many important undertakings make use of the same data center, for example. Who will be subject to this Digital Operational Resilience Act, DORA? It will be financial entities in the largest sense of the word. You look at the list, it contains credit institutions, payment institutions, but also, for example, insurers, reinsurers, insurance and reinsurance intermediaries, audit firms, institutions for occupational retirement pensions, crowdfunding service providers, crypto asset service providers, issuers of crypto assets. In other words, the entire financial sector, both banking and insurance, and everything that is related to banking, such as crypto assets such as crowdfunding is being caught by this Digital Operational Resilience Act. This is the first group. Then the DORA also applies to ICT third-party service providers. What are the main obligations that are being imposed? And again, the aim is to provide a harmonized framework for the financial sector in order to increase digital operational resilience. What are the different obligations? First of all, the obligation to have a documented ICT risk management framework to address ICT risks quickly, efficiently, and so on. Secondly, to manage ICT third-party risks. What do we mean by that? This is everything or every situation where you rely upon third parties to take care of certain ICT-related tasks, such as outsourcing. Third, the obligation to have ICT-related incident management processes in place. Fourth, an obligation to perform regular operational resilience testing and testing by independent parties. And last, an obligation, or not an obligation, but a possibility to exchange information on cyber threats and on intelligence in the area of cyber risk and cyber crime. Again, non-compliance with this proposed regulation may result in either administrative fines or remedial measures, for example, cease and desist orders or public notices, and importantly here also criminal fines or criminal penalties are foreseen for those that do not comply. Note that as this is in the sector of financial services, the authorities that will be competent for monitoring compliance with DORA will be the authorities that you know today, like the FSMA and in Belgium, the Belgian National Bank. This set of rules on digital operational resilience will of course be added to the existing rules that already exist both in the banking sector and in the insurance sector on outsourcing, the prudential rules on outsourcing, and also everything that needs to be in your outsourcing contract. This comes on top of all of this. Again, here the proposal has been made by the Commission. It is in the course of going through the legislative process. It will take about 12 to 18 months, it is expected, and probably it will be finalized only in 2022 and then enter into force. The last proposal that I would like to discuss is the Network and Information Systems Directive 2. What is this about? Well, as you may know, there is a Network and Information Systems 1 directive that is currently applicable, that has also been transposed, including in Belgium, however, a bit late. Well, this NIS directive was up to an update because of different reasons. First of all, of course, digital transformation of society, amongst others as a result of COVID-19, but also the expanded threat landscape. If you look at the incidents that occurred with Colonial Pipeline, for example, the attacks on certain companies, the threat landscape has become very much different today. And so the Commission feels that there is a need to adapt the NIS directive that we know today to the current threat landscape and to the current digital transformation of the society. What does this mean in essence? It means, first of all, strengthening the security requirements that are in the NIS directive, in the existing NIS directive. It means addressing also the security of supply chain, streamlining reporting obligations, and also introducing more stringent supervisory measures and stricter enforcement requirements. How is this exactly done? So what is the content of the proposal today of NIS2 directive? First of all, note that the scope of the NIS directive as we know it today will be expanded. That means that a number of additional sectors will be included in the scope. Think about, for example, the postal and courier services, but also food production, processing and distribution of food, and also manufacturing of certain critical products such as medical devices, computer products, electrical equipment, motor vehicles, and so on. So first of all, the scope will be broadened from a sector perspective. Secondly, all medium and large companies in the selected sectors that are subject to the NIS directive or the NIS2 directive will be automatically in scope, and there will be also a possibility for the national supervisory authorities to include smaller entities in the scope when they have a high security risk profile. So this is an option that is being left for the different member states and their authorities. Secondly, as you know, and this also relates to the scope, rather to the scope of the NIS directive. Secondly, the distinction between operators of essential services and digital service providers, as we know it today in today's NIS directive, that will be abolished, this distinction, and it will be replaced, in fact, by a distinction between, on the one hand, essential categories and, on the other hand, important categories. And this distinction will, of course, be made on the basis of the importance of the sector and the risk that there is for the whole system. The content of the obligations that are in the NIS directive will, of course, be broadened. For example, there will be stronger security requirements. There will be imposed risk management approach, providing a minimum list of basic security elements that have to be applied by those which fall within the scope of the NIS directive or the NIS2 directive. And secondly, there will also be more precise obligations regarding the process for incident reporting and also the content of the reports and the different timelines in order to ensure that everyone is informed as soon as possible. What is the possible impact for your organization? Well, first of all, we have talked about the broadening of the scope. So you should check whether your organization, if it is not already under the scope of the NIS directive, whether it will not fall under the scope of it in the future. Know also that there will be more stringent supervisory measures for the national authorities to ensure that the NIS directive is being applied and complied with. And also the sanctions, again, sanctions of 10 million or 2%. So the sanctions are being increased in order to ensure that the NIS2 directive will be applied and complied with. The timing here is, again, we are at a stage of the proposal. Adaptations are again likely. This is not the end of the story. This is not the final text. But once that the proposal enters into force, member states will have to transpose it within 18 months. So it will not be applicable before 2023. But for those that are impacted or that are likely to be impacted in the future by this directive, it may be wise to follow up on this directive, on this initiative, and where necessary, provide comments, make use of the possibility of public consultations, and so on. And this brings me at the end of our webinar today. As said in the beginning, it was not my purpose to go into every small detail of all of these new legislative proposals. The aim was really to provide you with a basic insight so that you, as legal counsel, know when someone talks to you about the Digital Markets Act, the Digital Services Act, that at least you have a basis. Of course, I think it is too early to go into every detail of these proposals, as these are, of course, still proposals. We will be, at Lydian, we will be following up on these different legislative initiatives. And once they are in further stadium, once they are more developed, we will be organizing webinars or hopefully live seminars, and also informing you through our eSINs. I thank you very much for having attended this. I hope it was helpful. Remember that the slides are available in the handouts section of this digital tool. Thank you very much and have a pleasant afternoon.